working with me today, and he will take your call. We're expecting somebody to call in because last week during the show I had somebody calling in talking to Sharina, the board operator, but she would not go live on the air with me for fear that she would be identified. She didn't want to give her name and give the specific details of her account. So I spoke with her after the show and I said, look, this is a great opportunity for other people to hear what's going on because your issue, although it's very personal to you, is an issue that a lot of other people are very likely encountering at the same time. So I thought I convinced her to call into the program. She's going to do that. She's going to call in. She'll be anonymous. So VJ, by the way, if this woman does call in today, make sure that when you put her live on the air with me that we give her an anonymous name and we will take her issue. But that's exactly why I'm here. Every Saturday morning at 7:30, I'm here to give you free legal advice. Doing it from my backyard today. You can hear the birds in the background. And I just want to mention a couple of things about my law firm and what I do in the event that you need to speak with a lawyer on a more personal level, on a confidential level. Then I make myself available 24/7. I have a toll-free number. It's 833-VASTOLA, and you can use that number to reach me 24/7. 833-827-8652. Distracted by the airplane going over the top of me right now, but that number forwards to my cell phone 24/7, no exceptions. So you can always reach me. You can always call me about anything. If it's something I handle, we can have a long conversation about that. If it's something that I do not handle, then I will likely make a recommendation for you to talk to somebody else about that. But I certainly will try to get you in touch with somebody that can help you right away. That's the objective of having a toll-free number available 24/7. So good morning, Don. Nice to see you. I was able to meet Don in person for the first time at our seminar that we had a couple of months ago. So thank you, Don, for attending that, and thank you for your constant input. It's always nice to know that people are listening and people are watching on Facebook. If you're watching on Facebook, good morning. Feel free to type in a question of your own if you want to do it that way. If I miss it, I've mentioned this before, but my little window on Facebook Live is only about this big and it scrolls up. So if I happen to miss your question, I will go back and watch the video afterwards and get back with you with hopefully an educated response to your question. Now, this is the way it works here. If you ask me a question and I don't know the answer to the question, then I will do the research and I will get back to you the following week with what I feel is an educated response to the question. This week, though, one of my topics is misappropriation, or what the statute calls unauthorized publication of name or likeness, because I often grab my topics for the show based on what's happened to me during my work week. And this week, not unlike many others, something happened to a client of mine. The client called me up and said, hey, can you help me out with this because I think I might have a case. And specifically, he found out that his picture was being used in an advertisement. Now, you know, initially that sounds like a fantastic case according to the statute. I might as well just kind of jump into it right now. The Florida statute that regulates unauthorized publication or name or likeness is 540.08. And if you weren't already aware, I mean, if you don't listen to my show very frequently, I will tell you that most laws originate in our statutes. And so that's why I'm always talking about the statutes, quoting the statutes, because in law school we're taught, at least I was taught, if you're going to be researching a particular issue, always start there. Because the law, wherever you live, people watching from Facebook Live, good morning, Mom, watching from Tennessee. I'm only licensed in Florida, so I only talk about Florida. But your state's laws, wherever you live, are comprised of many different sources. It's comprised of statutes. It's comprised of case law, which are the opinions that the appellate courts crank out almost daily, which are those judges writing those opinions are construing law, and so those written opinions become law. They become what we call stare decisis. It's case law. And then, of course, you've got other things like codes and ordinances, which can be county, city, statewide, whatever the case may be. So you have a lot of different origins of law, but we're taught, at least again I was taught, always start with the statutes, because those statutes are created by the Florida legislature. They are supposedly, the legislature that is supposedly listening to the citizens of the state and creating laws that are meant to be helpful or beneficial or protective of the citizens of the state. We know in real life that typically the laws that are created up in Tallahassee are created by very strong lobby groups, very interested groups that have a lot of influence up there, unfortunately. That may be a very, what should I say, jaded opinion of how things work, but I've seen a lot of laws passed over the years as a lawyer that don't necessarily help the citizens of the state of Florida. They help, more importantly, the companies that work in the state of Florida, which I suppose are due some protection as well. But those creatures of statute, the law that's created by the legislature, is going to take, typically takes priority over anything else. So, long-winded explanation as to why I always start with our statutes. And this particular statute, as I mentioned, is 540.08. And it, I'm sorry, VJ, I can barely hear you. Okay, let's talk to Judy live on the air. Good morning, Judy. This is Jeff. How can I help you?
Good morning. And I have a question for you.
Sure.
I live in an HOA, and I'm having a problem with a backyard neighbor. The neighbor moved in and installed floodlights below the roof, in the back of the house, very high up, and in the patio, again in the back of the house, in the rear of the home. The floodlights are turned on at night. The floodlights face my home, making it very difficult to sleep at night. I presented the issue to the homeowners association, to the board, to the management company, and they considered it a neighbor-to-neighbor dispute that needs to be resolved neighbor-to-neighbor. Do not know the neighbor moved in a while ago. This is a neighbor that has decided that he doesn't follow any rules. Rules are not for him. Yet there are rules in the community. What do you do in a situation like this?
Well,
This is causing a sleepless situation in plantation.
all right.
What
So,
do you advise?
I like the title of your topic, Sleepless in Plantation. That's good. So, Judy, what I'd recommend that you do is either on your own or with the assistance of an attorney is you file a lawsuit. The remedy, or the title of the lawsuit would be that of nuisance. You can file a nuisance lawsuit in Florida against somebody such as your neighbor, and you basically present the facts to the court as you're presenting them to me right now, and the court would hear argument from both sides, and the court would ultimately determine whether or not there's any beneficial purpose for these floodlights, whether they could be directed in another direction, taking into consideration both your interests and the interests of the other party. And typically the court will come to some form of a Solomon's decision here in splitting the baby, but try to make both sides happy. But certainly if somebody's infringing on your right to what's called quiet enjoyment of your home, that doesn't necessarily mean decibel levels. The right to quiet enjoyment means that you have the right to enjoy your home peacefully without intrusion, without very bright lights, glaring into your bedroom at night, that type of thing. So I thank you for calling in, but that's really simple advice to unfortunately a common situation. I don't know if you were listening to my show about a month or so ago, but I actually read from my Florida Law Weekly where somebody over on the west coast of Florida did exactly what I'm telling you to do. They had to file a nuisance lawsuit. They actually sought an injunction, which is what you can do as a remedy in your nuisance lawsuit. You can seek an injunction as a remedy because their neighbor didn't install floodlights, but had actually installed surveillance cameras that were looking into the neighbor's property and into the windows of the neighbor. So you certainly have some precedents here, and I'm sure there's probably 100 other cases similar to yours, but that's my advice in a nutshell, okay? Sleepless in Plantation.
Hard to hear you. Thank you. I'm going to try to speak to you off air. Okay. Thank you. Good morning. Bye.
Thanks for calling, Judy. I appreciate that. And thank you, VJ. I appreciate your help in getting her on the air. And so, yes, if anybody else is out there having difficulty with your neighbors, they don't have to be in the same HOA. I know oftentimes people are having disputes with people within the HOA, but oftentimes people live in areas where there is no HOA. And maybe you've got a lot of land, but you know the neighbor adjacent to you is creating issues. Probably the most common type of nuisance lawsuit that's filed is one neighbor suing another neighbor because the offending neighbor is having parties late into the night, and that's where, you know, quiet enjoyment takes a literal meaning, because somebody is suing to get them to be quiet after a certain time frame. Typically around 10 o'clock at night is what the courts will usually order. But again, the lawsuit is a nuisance lawsuit, and the remedy would be in some form of an injunction. And again, an injunction, if you have not been watching my show, because injunction has been a topic for the last several weeks, is either asking the court to get someone else to stop doing something that they're doing that is offensive, or an injunction can be proactive to ask the court to make somebody do something that they're not doing, but they are supposed to do, either contractually or by law. So anyway, those are different forms of remedies that are available. Thank you all for tuning in, by the way. This is Vastola on the Law, and I'm Jeff Vastola, and you can ask me anything you want. Even though Monday through Friday and oftentimes on the weekend I practice personal injury, wrongful death, product liability, all kinds of injuries and incidents, no matter what kind it is, a slip and fall, a trip and fall, a product liability, train accident, whatever it may be. Medical malpractice is included in all of that. That's what I do as a practicing attorney. But on this show for 30 minutes on Saturday, I open myself to everything and anything. So you can ask me any question you want, and I'll do my best to answer it. If I don't know the answer, I'll do the research. And that's what I'm doing now. Really responding to a client of mine that had inquired as to whether he could bring a lawsuit against a company that, in the initial discussion, misappropriated his likeness and was using a photo image of him that he, from initial discussions, did not approve of. However, as the discussion went along, it turns out that he was working as a model, had been paid a very insignificant amount of money to be a model for this particular company, and so the inquiry ended there, because this Florida statute that I've been talking about, the unauthorized publication of name or likeness, so it doesn't have to be your photo image, it can be your name. If somebody's published your name somewhere, and if it's unauthorized, then you can bring a lawsuit for that, and you can seek remedies, financial remedy. It's 540.08, that's the statute that I'm reading from, but the statute does set forth in subsection 4 3 areas where this statute is not going to be applicable. And one of those is any photograph of a person solely as a member of the public, and where such person is not named or otherwise identified, or in connection with the use of such photograph. This is not the situation that came up with my client earlier in the week. That's another one of the exceptions. That's subsection 4A, which basically says if you've consented to it, then you have no remedy. You know, you've been paid. You were paid insufficiently, perhaps, but that's all part of the contract. And so, as long as they've complied with the terms of the contract, then you really have no beef. Now, if they have not complied with the terms of the contract, then perhaps you have a breach of contract lawsuit, but you wouldn't have a lawsuit pursuant to this Florida statute. But, interesting anecdote about this. Many, many years ago, when I was a much younger person, I went on a surf trip to Costa Rica. And I went on this trip with a very good friend of mine that I've grown up with and still keep in touch with to this day. And quite a while after our surf trip, I got a phone call out of the blue from my friend who said, "Hey, Jeff, I was just on the plane, and they're showing an advertisement while you're sitting on the plane and you're watching the video screen before you take off of trips to Costa Rica." And he said, "You wouldn't believe it, but there's actually a clip which lasts about 5 seconds of you and me walking down the beach in Costa Rica." And he was all hopped up about that, saying, what can we do about that? They didn't ask me, they didn't ask you, they didn't get our permission, that kind of thing. Well, at the time I thought that was pretty interesting, and I looked into it, and I can't remember now exactly how I was able to see it. I think I had contacted the company to request the video that they played or something like that, but I did see it. And in fact, it was us. It was me and my buddy walking down the street, and not the street, walking down the beach in Costa Rica with our surfboards under our arms. And so I just looked into it more out of curiosity than anything else. And sure enough, the Florida statute, now, of course, this took place in Costa Rica, so you'd have to look at the law in Costa Rica. But if you were going to file the lawsuit in Florida, I suppose that even if you were to file it in Florida, they would apply the law in Costa Rica because that's where it happened. But if this were to have happened in Florida, then me and my friend would not have had a cause of action because it basically says in subsection 4C that members of the public, you really have no expectation of privacy when you are in public. And that applies really to anything. And this issue has come up several years ago on this radio show when somebody had realized that they were being photographed while they were in public. And it was not because they were famous and because it was the paparazzi, but because it was a private investigator. They were involved in an injury claim, and a private investigator was following this person around and taking photographs. If you're involved in a personal injury case, that is not unreasonable. It happens all the time, especially if you have a very significant claim. The insurance companies will spend quite a bit of money on private investigators to follow you around and take pictures or take video to see that, hey, you seem to be a well-functioning individual. You're not as hurt as you want everyone to believe you are. Those photographs and surveillance are very effective, if they catch you doing the wrong thing. So this particular person called the station and said, well, wait a minute, they just have the right to follow me around and they have the right to take pictures of me when I'm in the store and all of this. And the answer is yeah, in Florida they do. There is an expectation of privacy, and so there is a limit to what a private investigator can do, and it really boils down to this. In areas where you have an expectation of privacy, then they cannot do it. And so, for example, they cannot go up to your bedroom window and start taking pictures into your home through your window, even though arguably they can see through the window. There's an expectation of privacy in your home, and so they can't do something like that. If you're in public but in a bathroom, you have an expectation of privacy when you are in a bathroom, and so they can't follow you into the bathroom and maybe take a picture of you over the stall or under the stall, or perhaps even in the bathroom if you're even at the counter. That would be an interesting argument to know whether that's a violation of your expectation of privacy or not. I haven't looked into that, but most people with couth would know you're not supposed to take pictures of anybody in a bathroom. You might get yourself beat up if you do that. I'm not encouraging that. I'm not condoning it, but that's just the reality of things these days. I was in a deposition one time, another personal anecdote. I was in a deposition one time, and there were multiple attorneys taking the deposition of a witness. She was not a party, she was just a witness. And I was messing with my phone. This is a long time ago. This is not one of the, a newer smartphone which can take pictures silently. And I wasn't taking a picture of her at all, and I wasn't taking a picture on purpose, but I was messing with my phone, and my phone was face down on the desk, but as I was messing with it, I hit the button, and it was one of those phones that would make the noise of an old-fashioned camera, make that picture-taking noise. Well, it made the noise, and the witness, looked over at me and thought that I had taken her picture. And, she got immediately upset, saying, "Why are you taking my picture? You're not allowed to do that." She was already upset that she was there having to give a deposition as a witness. And, of course, I immediately had to kind of defend myself and say, "No, I'm sorry, hit the button. I was not taking a picture of you." I think I might have even showed her the picture of the top of the desk that I took the picture of. But anyway, if you're in public, and if you were to ask me, well, Jeff, did you have a right to take her picture? Then I probably would have said, yeah, I think I do, because in a deposition setting, there's really no expectation of privacy. You're there, you're among public. I could be wrong about that, haven't researched it, but that's not all that uncommon. There's a lot of times that defense lawyers will ask to take a picture if it's a plaintiff's deposition. They'll say, do you mind if I take a picture? Especially if obviously if there's an injury involved to the foot. I've had that a lot. If there's an injury to the foot or injury to the leg or the knee or whatever it is, they'll want to take a picture of that. But that's tangential, I think. But anyway, if you are ever wondering, what are my rights when I'm, in public, and can somebody take pictures of me and take video of me? Well, the answer is yes, they can, as long as you don't have an expectation of privacy. And if you're interested, again, that's Florida Statute 540.08. Let me see, I've got just a few minutes left. Wanted to talk about a couple of cases from my Florida Law Weekly. So it looks like the tide is going out. For a lot of years now, the plaintiffs have had the upper hand when it comes to the admissibility of medical bills, and specifically the charges when you go to trial. It's been favorable for the plaintiffs for quite a few years now, where if you are injured and you have an injury lawsuit and you're going to go to trial, what the law, according to a case called Jorg, J-O-E-R-G, yes, J-O-E-R-G, it's a Florida Supreme Court case. A lot of lawyers and then the judges were construing the ruling in Jorg to say that what the plaintiff was allowed to show to the jury were the total charges. Now, as anybody knows, any adult knows, the total charges are not what are paid. The insurance company, whether it's Medicare or a private insurer, they will pay typically a very small portion of the actual charge. And then if somebody has a Medicare provider number, or if you are in contract with a particular health insurance company, the provider is obligated to write off the difference. So if they bill $1,000 and they get paid $100, they have to write off $900. They can't charge that back to the patient and try to collect that $900. Now, there are times when they can. If it's a provider that is not in network with a private health insurance company, meaning they're providing these services out of network, then they oftentimes will accept what the insurance gives them as an out-of-network provider. But then they have the right to what's called balance bill the patient. They can go to the patient and say, hey, we only got $50 on our $1,000 charge. You owe us $950. So just be careful if you're going to be utilizing providers that are out of network, because that's essentially how it works. But I wanted to let you know the tide is changing, plaintiffs, and there's a case out there now, and it's a 4th DCA case, which is directly affecting me and my practice here locally in Palm Beach County, Broward County, Okeechobee, and all of the Treasure Coast. That's all of the 4th DCA. It's a case of Gulfstream Park Racing Association versus Margaret Volin. And this was a case that was down in Broward County, but again, it's a 4th DCA case. I'm about to get rained on here. And it says now that the opinion in Jorg has been misconstrued to suggest that total charges were admissible to a jury. And the Gulfstream case said that what's only going to be shown to the jury are either what was paid or what is still outstanding. That way, the jury has a more realistic understanding of what the plaintiff actually owes. Because in the past, we would show to the jury the total amount of charges. So let's say the total amount of charges was $100,000. Well, that doesn't necessarily mean that that's what the plaintiff owes. Oftentimes, things were paid, and because somebody was in network or because it was a Medicare issue, things were written off. And sometimes it's not always an outstanding balance. Well, the argument has always been, in support of that, that the jury should have an understanding of all aspects of the case and then make determinations based on every aspect of the case. Now, this Gulfstream case, it's interesting to know whether or not the plaintiff is going to be able to introduce the total charges and then what's actually owed, because, and in my opinion, that's how it should be done, because that way the jury truly does have a complete understanding of the entire thing. But this case specifically holds, now this is a 4th DCA case, it's not the Florida Supreme Court, and so now we've got some dissension among the DCAs, and so the Florida Supreme Court is ultimately going to have to rule on this to make it the law of the land. But it seems to me that because of the title shift, the Supreme Court is probably going to agree with Gulfstream. That would be my guess. If I were a betting man, I would bet that moving forward, the plaintiffs are only going to be able to introduce what is owed or what has actually been paid. Now, in the old times, it wasn't as if the plaintiffs would get that windfall if the jury said, wow, total charge is $100,000. Okay, here you go, $100,000 in a verdict. Post-trial, the judge would take care of all of those issues and render the judgment after all of the reductions were made. So that's how it works. I believe that I'm running low on time. VJ, what do I got? 1 minute. All right, so next week we're going to talk about the difference between operational levels and this is a case called, oh, I'm sorry, I'm looking at the wrong case. That's why I'm so confused. School Board of Broward County versus Sebastian McCall Jr., another 4th DCA case. We're going to be talking about sovereign immunity and when the state, its agencies, or subdivisions have absolute sovereign immunity, meaning you absolutely can't even bring the lawsuit, versus when you can bring the lawsuit but be subjected to the caps that are in Florida Statute 768.28. Thank you very much for tuning in. I see Kevin O'Brien is watching. Kevin, I hope to see you one day soon. And if you'd like to reach me anytime, 833-VASTOLA. That's 833-827-8652. Until then, have a great weekend. God bless.